of the Center for Intellectual Property Law, which I direct. As many of you know, I'm Professor Irene Manta, and today we'll be hearing about alternatives type A. Before we do that, I would like to thank very much our donors. You have them here, Gladys and Perry, Mr. Rothstein and Evanstein, and then as far as individuals go, Joshua Boydman, Scott Foreman, James Harrington, and Joe Shetty. So thank you, some of them are here. We're very grateful for your support and to be able to do this. And we're glad we can resolve Dean Lane, since his regrets, he's flying back from California. He would love to be here, so he's here in spirit. I would like to, with that, to introduce our esteemed guest, Professor Michael Abramowitz from George Washington, who has a bachelor's degree in economics from Amherst College and a JD from Yale Law School. Before teaching at GW, he taught at George Mason University. He has published in all of the top journals in the country, at Yale and Harvard and Stanford, Columbia, NYU. So he's really one of the experts in the area. He focuses on law and economics, intellectual property, but also other areas such as civil procedure, corporate law, administrative law. So with that, let's give him a hand, and we're looking forward to it.
I'm very excited to be here. I just want to thank Professor Manta and the Center and the Law School and the University for inviting me, and all of you for coming. I realize it's a hard sell to think about intellectual property and alternatives at 6 p.m., so I really do appreciate everyone's coming. And so really, this stems out of a variety of kind of projects that I've worked on in the past, and I'm hoping eventually to kind of pull into a book. Some of these things I haven't really written full articles on, and so I'm thinking about it, so it'll be very helpful to get your questions, your skepticism as well, if you have any, about some of my ideas. And I realize many of you probably know a little bit about intellectual property, but just as a sort of a very basic idea about IP, and in particular patent law, which will be my focus more than copyrights, although we can talk a little bit about copyrights too. Basic way things work in this country and really around the world is if you create some kind of new invention, better mousetrap, as the phrase goes, but also maybe literally some kind of better mousetrap. You apply to a government agency, the United States, the Patent and Trademark Office, and assuming you meet certain requirements, you are awarded a patent. And a patent is a property right. It gives you the right to exclude anybody else from, among other things, practicing your invention. So if everybody else sees this great mousetrap, they want to sell the same mousetrap, either have to buy it from you or get a license from you, and that, of course, allows you to make money. Of course, the purpose of all this is to give people incentives to produce things that are useful not just to themselves, but to others, to build those better mousetraps, to build lots of other exciting technologies that you might imagine. And that's the system that we have. And I'm actually pretty much a fan of this system. I know there's a lot of people who are very skeptical of our patent system. I think they have a lot to add to the conversation as well. I actually think it works reasonably or tolerably well. But it's also possible to imagine very different kinds of systems. Systems that don't necessarily involve property rights that you get for having contributed an invention. Other systems for encouraging research and development in new technology. And so one of the sort of very broad distinctions that I'd like to draw is between patents and some of these other systems. Let's for now use the word prizes very broadly. I'm going to kind of narrow down what I mean by prizes in a bit. And rather than give you the case for prizes, I'm actually going to start with the case against. I realize you may not be able to read that on that screen, although maybe you have the slides anyway, but I'm going to read it to you. And this is a quote from John Stuart Mill, 1858, and I think he really kind of hit the nail on the head, at least in summarizing the argument for why we have patents rather than a system of prizes. Okay, and so he says, in general, an exclusive privilege of temporary duration is preferable. So temporary duration refers to the fact that patents only give you exclusivity, that exclusive privilege for a period of time, say 20 years, because it leaves nothing to anyone's discretion. That is, according to Mill, government officials don't have any say in whether you're going to get the right or not. Clearly, Mill doesn't trust the government very much. That's one reason. We're going to come back to that. Because the reward conferred by it depends upon the inventions being found useful, and the greater the usefulness, the greater the reward. So this is kind of his second point, this notion of proportionality. That is, if you invent something that's lousy, well, if the government just kind of was maybe rating your invention, giving you money for things instead of giving you a property right, maybe you would say you deserved a lot. Or if you made something great, maybe the government would say you don't get very much. But he said, no, the great thing about property rights is that the reward you get as an inventor is going to be proportional to how good it is. Is it a much better mousetrap, a slightly better mousetrap? The better the mousetrap, the better the invention, the more money you are going to receive. And finally, third, because it is paid by the very persons to whom the service is rendered. Right? When you invent that better invention, how do you make money for it? Ultimately, by charging more to consumers. Right? Consumers will be willing to pay more for your invention than for what came before. And Mill says that's a good thing, right? Because those are the people who are benefiting from the invention, the people who are using it. And so the great thing about the patent system, he says, is that it makes sure that the people who are benefiting are those who actually pay, the consumers of the commodity. So decisive, indeed, are these considerations. He thinks this argument is so powerful that if the system of patents were abandoned for that of rewards by the state, the best shape which these could assume would be that of a small temporary tax imposed for the inventor's benefit on all persons making use of the invention. So this is a very clever little argument that he offers at the end. He says, well, if we couldn't have a patent system for some reason, then we should, and instead the state were simply going to give people money based on how good their inventions were, well, then we would try to make it in a way that would make it awfully similar to the patent system, right? We would, in the end, say, we're going to tax the people who are using the invention. And he says, well, that's kind of silly. Why have the government tax the people who are using the invention? If the government would have to figure out the tax, that would be very cumbersome. And it would be kind of like the patent system, which is much easier from his perspective because the inventor can simply decide, or the commercializer, authorized by the inventor, can decide how much to charge. Okay, so that's John Stuart Mill's argument against having some kind of prize or reward system rather than patents. And the question is he right? And so let's kind of review those three arguments that he makes and try to suggest that he certainly has a powerful point, but that there are counter-arguments on the other side. And my purpose here today is not to definitively resolve anything. I'm not trying to convince you that some kind of prize or reward system is better than the patent system. I think there's a lot of empirical uncertainty. I think any kind of new system would need a lot of experimentation, and there's lots of reasons to stick with what we have. But I do think the case is perhaps a little bit more complicated than Mill allows. And so let's talk about those three arguments that Mill makes in a little bit more detail. So first, he says, well, look, the great thing about the patent system is that there is no discretion by the government. Well, I think those of you who have taken patent law, and really those of you who have taken any kind of law at all, by now have certainly realized that there are lots of closed cases in the world. And it's not just that, the case books find the few closed cases. It's that any set of complicated facts leads to difficult judgments, even where we have legal standards. And I think that's definitely true in patent law. We have certain requirements for obtaining a patent. Some of them are relatively bright line, relatively easy to apply. There are others that are extremely difficult, and that have been difficult for hundreds of years. And maybe the courts are getting better at them, such as the non-obviousness test. One requirement, if you want a patent, is that you have to show that the invention is non-obvious to a person having ordinary skill in the art. Well, suffice it to say, there's a lot of disagreement about what that means. Supreme Court a few years ago, in a case called KSR, tried to kind of make sure that the courts were applying that pretty rigorously. Maybe the Supreme Court felt that the Patent and Trademark Office was being a little bit too lenient in terms of granting the patents that it was granting. So there's certainly room for disagreement about whether a particular invention meets that requirement and whether a particular invention meets some of the other requirements of patent law at all, as well. So this idea that there's no discretion, it's sounds good, right, when you kind of visualize an invention as being something very concrete, like a mousetrap of a particular kind. But actually, once you realize that there's lots of inventions that are pretty similar to one another, trying to figure out whether or not an invention should be entitled to a patent is quite difficult. That's why we need patent lawyers, right? If it were completely obvious, we wouldn't really probably teach patent law because we couldn't make any money in it. It would just be a very easy thing to do. So that's one source of discretion. Second source of discretion is that eventually we have litigation. And you might think, well, after we've already had the patent office make its decisions, the patent carries a presumption of validity. So it's a very powerful document. You might think, well, that makes it easy for the court. But no, the courts still have lots of work too. Lots of cases with dissents, as you've seen in lots of other areas of law school, disagreements about still whether the patent is valid, and then also about whether a particular, whether the defendant's product or service infringes on the patent. So there's lots of room for discretion. And what does that mean? Well, of course that means that from a social perspective, the patent system is expensive. We need to hire lawyers, we need to argue about patents, and that costs a lot of money. And that's what Mill was concerned about with pricing. He said, it's going to be expensive once you have government making arbitrary decisions, or not arbitrary decisions, any kind of decisions requiring discretion, that's going to be expensive. That was his argument. So then the question is, well, which is worse? And we can talk more about that, but you can argue about it. Now, the second point that he makes, of course, is this argument about reward proportionality. The better the invention you build, the more money you get as an inventor. And there's certainly something to that. Certainly in history there have been some great patents that have made people very wealthy. The Wright brothers, for example, after a lot of litigation, did pretty well with their invention of the airplane. Actually, really, the invention of something that allowed airplanes to work. And so they got a lot of money. People who invent lousy things often don't make much money. The vast majority of patents actually turned out not to be very valuable. So there's something to what Mill says. But there's some reasons to think that it's not a perfect system. First of all, there are some patents out there that, there's a lot of disagreement about how many, but that are low quality. There are some patents that probably, some of them make some people some money. Maybe just by being able to threaten litigation, you can get people to pay you some money. But sometimes people are awarded patents that they probably shouldn't be awarded. There's some famous examples of some of these, and some of these probably don't make that much money. Like patent for swinging on a certain way on a swing, things like that. But there are some low-quality patents out there for routine-seeming inventions. People are making money off them. Maybe they shouldn't. So that's an example in which somebody's making money, but maybe should not be. A second point, which I think is pretty fundamental, is that our patent system does not do a very good job of encouraging basic research. And some people say, well, that's fine. We have other ways of encouraging that. We're going to come back to some of those ways in a couple of minutes. But one might, in theory, like to have one system for encouraging research and development that encourages basic research and applied research. So fundamentals of chemistry and physics and biology, as well as inventions that take advantage of those principles. The farther along you get on the continuum toward basic research, the less likely you are to be able to really profit on it from the patent system. And what that reveals is just that patents don't necessarily map onto, very well, the value that an inventor's contribution provides to society. And it's certainly obvious with really extreme things. You come up with really abstract ideas, some of them can't even be patented. But even as you move along in the continuum toward invention, there are inventions that may be a big deal, but it's kind of hard to figure out a way to describe them in a way that entitles you to a patent. Okay, and then third, there are some just weird distortions in the patent system that fundamentally affect how research and development is allocated. Now, one area that a lot of people say is actually a relatively good example for the patent system is pharmaceutical drugs. And the reason people say this is a pretty good argument, that some people are very concerned about this area, because they think we don't want people not to be able to get drugs. But putting that argument aside, people say, well, it's a pretty good argument because it's relatively easy to describe the property you're entitled to. You can, in many cases anyway, produce a chemical formula that really clearly identifies a particular invention. Nobody else has invented that chemical formula. Maybe you've invented it, assuming you meet the other requirements of patentability, you get a patent. Nonetheless, there are reasons to think that there are some distortions in our drug system. So, one recent article, not by me, argues that we have a distortion in production of cancer drugs, favoring cancer drugs that address late-stage cancer rather than early-stage cancer. And maybe, therefore, maybe that gives people maybe a few months left of life, extra months of life, at a time when you can't really do that much more than that, rather than that potentially can make a bigger difference and affect more years of life. Why? Well, because our patent system only gives you 20 years of patentability. And clinical trials take a long time. Well, if you do clinical trials for people who are expected to only to live a few more months, they don't take as long. So there's a bias toward having drugs where the clinical trials can get done quickly, then you can sell the drug. Maybe it'll help other people as well, but that is sort of a distortion in our system. Not as much incentive to patent drugs and go through the whole clinical trial process if you can get some of the time back because of delays at the FDA, things like that. But you're not going to get all your time back, and you might have a very short patent, if any time at all, if you have to go through a 20-year clinical trial to see if something works. A second point that's quite interesting is that imagine that some scientists are looking at a particular disease, and they think about some potential candidates. They say, one thing that would be really good to try is X. We should try drug X for disease Y. And they write that in a scientific publication. You might think, okay, now the pharmaceutical companies are really going to want, they're going to see reputable scientists think we should try that. They're going to want to try that. Well, it's been documented that many pharmaceutical companies have a process that eliminates all those drugs from their pipelines. That is, they actually have researchers go, they research the literature to see what are people suggesting that we do. And whatever people suggest, we're not going to do. That's a little bit of an extreme statement, but there's certainly some activities along these lines. Why? Well, because inventions have to be non-obvious. And the concern is, if a scientist specifically said this chemical formula for drug X might be good for disease Y, then I bet you're never going to get a patent, or you have less of a chance of getting a patent. So why spend $1 billion on clinical trials, which are likely to fail anyway, for an invention that you're not likely to get a patent for? So another example of how maybe patents aren't always reward proportional. You don't always have the incentive to invest money in proportion to what you think the benefit will be to society. Okay. Third point that Mill made. He said it's great that consumers pay the patentee rather than having the government pay the patentee. And there is an argument there. Again, it often makes sense for people to pay for their own stuff for lots of reasons. And one way to expand on Mill's argument is to say, look, taxation, right? If the government pays for things, it has to tax. And taxation is distortionary. Taxation changes people's decisions. People won't produce as much stuff, as much economic activity, let's say, if they think that ultimately they will face some kind of tax, and it may lead them to produce more of some things than others. Those are distortions associated with taxes. People pay for accountants. People do lots of activities to try to avoid tax. So taxation is kind of we need taxes, but inherently somewhat inefficient. So that sort of supports Mill. On the other hand, patent law has its own inefficiencies. And the classic inefficiency that economists talk about with regard to patents is deadweight loss. And the basic idea of deadweight loss is that sometimes consumers may value an invention at more than 0, but at less than people are charging for it. Right? Imagine a drug again. Something that's in a pill. Let's say the pill costs only a couple cents to make, just to make it an easy case. But the pharmaceutical company wants $100 a pill. Well, there may be some consumers out there, they would value it at $50 a pill, but they're not going to pay $100 for it. So the deadweight loss is the fact that they would receive $50 worth of value, they're not going to end up buying the pill, and that's a loss to society. If the government ends up buying the drugs, then the government can give it away for free. I can say anybody, for just the cost of production. I can say anybody can produce this drug. So if it only costs a couple cents to make, once you know that it's a good drug, then anyone can produce the drug, and it can be available much more broadly. So these are 3 reasons to think, not that Mill is wrong, but at least that the situation is more complicated. That maybe in some contexts patents are the best thing, in some other contexts, maybe some kind of prizes or rewards might be better. So how can we think about this kind of problem more broadly in terms of thinking about what society should do? And I like to think of patent law as one in a family of mechanisms. Patent law is a mechanism that takes some governmental decisions, in particular for patent law, it's decisions by the Patent Trademark Office, decisions by judges, and then encourages market actions in the face of the decisions. Things like licensing, when people pay to license the use of a patent. And so the idea of the system is that we don't need to have the governments supervise every license payment. We just need a few decisions, and then the market organizes itself around those governmental decisions. So, can we think of other mechanisms that sort of work in the same way, where we have a few governmental decisions, and we have lots of market activity organized around those decisions? Well, what would be the goal of such a system? Well, we want to maximize the following. We want to maximize the social welfare gain from inventions produced. How much value does it give to individuals across society, minus the cost of research and development, how much do you have to pay for it to produce it, minus the administrative cost of the system. Things like patent litigation, for example, the cost of prosecuting patents at the Patent and Trademark Office, those would all be part of that calculus. And then, so the big question is, if we're starting to think about alternatives to the patent system, and we're thinking about, can we do better? How can we do better, potentially? Well, if we can improve alignment of social and private gains, that is, if we can make it so that the amount you get as an inventor is more closely correlated with the benefit to society, better inventions, again, doing better than less wonderful inventions. If we can reduce administrative costs, and, kind of coming back to, I think, Mill's core concern, potentially reduce the chance of political influence. So Mill really worries that if it's up to the politicians, it's going to depend on who knows whom, who thinks something sounds good, rather than on what people really need. And so as we think about some of the mechanisms that I'm about to start talking about, we should evaluate them based on some of these criteria. Now, I want to make a little bit of an aside. That there are some ways that the government promotes research and development that are quite separate from the different mechanisms we're going to focus on today. For example, tax credits. We have in our tax system an R&D tax credit. And so you might say, well, that requires very little governmental decision. All it requires is the verification of spending on R&D. We have markets organizing around that, private parties invest. But I'm not really including this in what I'm interested in today. I'm not saying it's good or bad. Because tax credits depend ultimately on other appropriability mechanisms. The only reason you're willing to invest and then take it in research and development and take advantage of the tax credit is that you think there's some reason you'll be able to make money back. Maybe through a patent. Maybe through first mover advantages. Maybe through trademark. Somehow. So a tax credit is not in itself an appropriability mechanism. And what I want to talk about is appropriability mechanisms. I want to talk about mechanisms that the government can provide that allow people to take advantage of their inventions and ultimately profit from it. A tax credit can kind of multiply the profit, but it's a little bit separate from what I want to think about. Ways of allowing people to appropriate, overcoming free riding from people copying their invention. So let's start talking about prizes. And when I say prizes now, it's sometimes used rather loosely, but what I mean is when the government essentially says, here's an invention we want. We will pay money, maybe a specified amount of money, for that invention. And interestingly, this has a very long history. And really for a long time in history, the prize systems competed more or less on equal terms with the patent system as ways of encouraging research and development. The most famous prize ever offered was the Longitude Prize. It was a great book written about the Longitude Prize. And the idea was that at sea, there had been established a mechanism for determining latitude based on looking at the stars. But no one was able to figure out a way of determining longitude. And that's very valuable. Why? Because you want your ships to be able to go in the right direction. And that's the short version. Many people died as a result of the lack of an ability to determine longitude. Ships went the wrong way, and bad things happened to many sailors. This was very valuable to England, and the hope was maybe somebody could come up with some kind of map-making method, with mathematics to do so. And eventually, an inventor invented something that people actually did know, if you could invent it, would solve the problem. And what he invented was a watch, a timepiece. A timepiece that you could travel onto a ship, bring onto a ship with you, and that would maintain accurate time even though it was on the ship. There were already clocks. But you couldn't bring your big grandfather clock on the ship and hope that it would work. Even if you tied it down, the movement of the ship would mess up your grandfather clock. So somebody who was not really thought of as a scientist, but was maybe a mere craftsman, invented a watch and applied for the prize. And initially, England said, the commission devoted to the Longitude Prize said, we're not going to give you the prize because we don't think you actually have an invention. And they actually had some good arguments. And one of the arguments that they had was that he only produced one watch, and it took him a long time to make that watch. I mean, he spent years making the one watch. He did not produce a general system for making watches. He couldn't quite explain how you would make another 100 watches that could be brought on. So he could give the one watch, and they could pick which ship they were going to put it on, but that was it. Once you could put it on that ship, then people could figure out. The idea is if you knew how much time you were away from shore, and you knew the latitude, you could figure out the longitude. I don't know the details of the calculations, but that was the idea. Anyway, so that was a famous prize and a famous controversy. Eventually, he did get a fair bit of money, but not the whole prize, from England as a result of the invention of the watch. And so that was maybe an example, and I actually have a quote, I think, on the next slide down here, that even in the relatively simple case, where the legislature sought to promote a solution to a single specific problem, right? They said, this is the problem. And there was a single discrete product that embodied the sought-after invention. Parliament was not able to usefully specify the test that would determine whether the invention had won the prize in a way that would eliminate the need for administrative discretion. So, if you think about the challenge of, as Mill thought about it, as minimizing administrative discretion. Even, you might think, oh, prizes are great, right? You just say, here's the invention that we want, you invent it, we give you an answer. Well, not really, as the Longitude Prize showed. Did you really invent it? Did you not invent it? There's lots of room for interpretation. But the Longitude Prize was just one of many, many prizes. And what's interesting is that it began to decline in England in especially the 19th century, partly as a result of the changing role of Parliament. There was the sense Parliament, to some extent, acted as a kind of quasi-judicial body in many contexts. And as Parliament became more legislative and less judicial, the prize system didn't fit very well with the role of Parliament. And so some people have said, well, the prize system declined largely, for random historical reasons. I actually don't quite believe that. I think the prize system declined. That was kind of one reason, but there's sort of deeper reasons that the prize system ultimately turned out to be not very effective. And indeed, there were other countries that had prize systems too. Japan had a fairly well-developed prize system. It declined there as well. So that's sort of the old history. Interestingly, there's been a modern revival, really, especially in the last 15 years, of interest in prizes. There's some legislation, for example, in the United States. DARPA, the Defense Advanced Research Products Agency, I think is what it stands for, has some periodic prizes. For example, there was one for driverless cars. You could win get over something. The first year, none of the cars were able to do the course, and the next year they all did it. Department of Energy has some grand challenges. NSF has some prizes now as well. So there is now some set of prizes within our government for encouraging inventions. And there are some philanthropic and private prizes as well. The Virgin Earth Challenge, the Ansari X Prize, private organizations that say, hey, if you can do this, we're going to give you some money for doing so. And note that they tend to be focused on things that the patent system isn't likely to be great at. So the Virgin Earth Challenge, you can figure out a way to kind of eliminate, let's say you can figure out a really expensive technology for eliminating kind of the concerns about global warming. You can suck the air in and take out the bad stuff, the carbon, the methane, whatever. It's going to be very hard to make money off of that. Why? Because people will just wait 20 years for your patent to expire, right? Well, great, you invented it. What's the rush? Well, there's not going to be any global warming now that we have your great invention. We'll just wait 20 years, then it'll be in the public domain, and then we'll, if it starts getting a little warmer, then we'll turn it on down the line. So I think people realize the patent system is not going to be very good for combating climate change. So here's an example of where the patent system doesn't work well, the prize system kind of maybe fills in, but the amount of money we're talking about is tiny, tiny, tiny relative to the problem with global warming. If you could have a patent system that really would reward people proportionally, right, there'd be a $1 trillion prize rather than I can't remember how much the prize is, but something in the millions. Okay. Some other problems with prizes. The government has to figure out what future inventions will be valued. If you don't think government's so good at exercising its discretion, you might think they might miss a lot of important things. They might think some things are important that aren't very important. They might make their decisions based on what people they care about, whether political supporters or family wants to have rewarded, rather than based on other considerations. Okay, I'm going to skip this slide and go to rewards. This is actually an area where I've written a little bit about trying to differentiate them from prizes. So prizes, government comes up with a specific goal, and whoever gets to that goal first typically gets the prize. Rewards, we might say something a little broader. We might say, okay, we have an area we're interested in, potentially a broad area, and you can submit your invention, and we're going to have some kind of fund. And we're going to basically divide this fund in proportion to how good your contributions are, right? It might be that somebody has a great contribution, they get a lot of the fund. Somebody else might have a modest contribution, so they still get some of the fund too, but a smaller amount of the fund. And so we have decisions that are essentially being made ex post, and potentially in a much more open-ended way. And so the concern, and I think this is what Mill actually uses the word rewards, and I think this is what he was talking about, and to some extent thinking about something a little bit like concerns about rewards. And he was worried that government wouldn't do a very good job of granting rewards. But there are some ways that we might imagine improving a reward system. For example, suppose we have some kind of fixed fund, right? We said the government says, we're going to allocate $10 billion as a fund to reward pharma development. This has actually been proposed. I'm not sure if the number was 10 billion, but by Senator Bernie Sanders. So Senator Bernie Sanders has a bill, or had a bill, I think no one else signed on to this bill, saying we're going to get rid of the patent system for pharma, and instead we're going to reward people based on how good their drugs are. Right? We're going to try to measure how much do they improve the quality of life for how many people, and we're going to reward them through that. Well, one virtue of this proposal, and I think there's certainly some vices as well, is that it uses a fixed fund. So if you're worried that the government might say, okay, yeah, you do great things, we'll give you money, and then say, oh, we don't have enough money, so we're not really going to pay you, or we'll pay you, $1 instead of the $100 million you're entitled to. Committing in advance to a fixed fund can be very useful. Similarly, if you're worried that the government might pay too much, right, the government might say, oh, I understand that you're an important political supporter. I wouldn't say that out loud. You had a great invention. Again, you might think that a fixed fund is better because that at least limits the government's total exposure. Meanwhile, the other advantage of a fund is that we can make the assessments ex post. But a lot of early proposals for rewards, imagine, a person comes up with the invention, boom, applies for the reward, gets it, or doesn't get it, all in a short period of time. Most of the more recent proposals, including mine, but then there's some others, one's called a Health Impact Fund, they actually tried to implement, not with success yet, in a variety of countries. The idea is we're going to delay, we're going to wait to assess how good your invention is. The money in the fund will accrue interest or something in the meantime, but we will actually distribute the fund maybe 10 years from now, 15 years from now, when we'll have better evidence of how many people are actually using the invention. Still, it's not trivial. It's still hard to measure how many people use a particular invention, even when it's something like a drug, but that may potentially make it a little less subject to governmental discretion. And part of the idea is, well, there might be mistakes, right? The government sometimes might give somebody too much or somebody too little. But as long as the inventors sort of can't anticipate that in advance, there's such a delay, and maybe it's a judicialized system, so they don't know who's going to make that decision, those errors might produce windfalls for some, and I guess the opposite of windfalls for others, but at least people deciding whether to invest will be deciding it based on some expected average of what different people would give them. So these kinds of this potential for errors won't distort investment towards bad inventions and away from good ones. You're best off investing, for the most part, in good inventions. So that's a system of rewards. Okay, and so that one can think about kind of a simple typology of alternatives to IP. And prizes, those are judged ex post. The ideas are generated by the government. The government says we need longitude, we calculate longitude, and then you come up with your invention. After the invention, you get your prize. You can think about the opposite extreme, you can think about research grants. Ideas generated by private parties. They come to the government, and they say, oh, I'd like to write a paper about, do an experiment on X. The government says, oh, that's a bad idea, or that's a good idea. If you think it's a good idea, you get funding. So ideas generated by private parties and judged ex ante. Rewards are ideas generated by private parties and judged ex post. Right? We're going to wait to judge what you get after you do the invention, and maybe even later than that. And of course, you can have the opposite extreme to that, which is direct governmental provision or some kind of system of procurement. The government can say, well, what do we need? We're going to go ahead and do some pharmaceutical investment ourselves, or we'll hire some company to do so. We don't see much of that outside of, let's say, the defense industry. In the defense industry, we need a certain kind of airplane, so we're going to pay the defense industry to do it. Government decides what it wants, and it decides on the contract before it even gets the invention. But there are other possibilities. I'm not going to have time to go through all of these, and I want to allow some time for questions. But I do want to briefly identify a couple of these, and maybe I'll talk about one or two. So here's sort of the typology of IP alternatives. This is kind of a typology of how we can think about things using property. So obviously we have patents, right? How much, who generates the ideas for patents? Inventors, private parties. And how much do you eventually receive, and when does the government make decisions about whether you get the patent? It's after you produce your invention, right? You say you apply to the office, you get your patent, or you don't get your patent. So that's why that's over here. But we can imagine some other possibilities as well, and think about whether they make sense. Sometimes you might imagine, for example, that the government would generate some kind of idea saying, we need inventions in category X. Maybe, for example, Scientists think that a particular biological pathway would be a good pathway to explore for a cure to a particular disease. And you could just let people get patents, but if you think this is an area where patents don't do such a good job, because maybe the disease takes too many years to do the clinical trials, for example, you could imagine something quite different. You could say, maybe the government should have an auction. So here's how it might work. The government might say, we are going to auction the right to have any drug in this category. No drugs exist yet in this category. But we're going to auction off the right to this entire category. And maybe we'll give it, you can imagine different ways of conducting the auction. Maybe we'll give it to the company that promises to do the most research and development. Right? We can say, you'll get an exclusive right, but we're only going to give it to the company that promises to put the most money into this problem as a way of encouraging research and development. Or you might say, we'll give it to the company that promises to charge the least for the drug once it's actually produced. And there's other approaches that you might use. So I have a slide on, come back to this, on auctions. Or you might say, somebody who agrees to the shortest term, right? How many years you can get this right? Maybe some people would do it for a 30-year term. Other people would want 50 years for something that's going to take a long, long, long time to do the clinical trials. So an auction is a potential alternative to IP in a context in which we don't think the patent system does a very good job, but we think that property rights might be pretty useful. What are some problems? Well, there's still a lot of discretion that the government needs to engage in. Not so much about which invention, but about how to structure the auction. How much should we weight these different considerations, like cash payment to the government, or commitment of funds to R&D? How important are these relative to one another? It's hard for the government to do that. And of course, the government has to decide what categories of inventions are sufficiently important that we want to actually have auctions. What categories are areas where we don't think the existing patent system would do a good job. Okay, now I want to talk about one more mechanism. I have some more that I don't think we'll have time for. Let me talk about one more mechanism that's a little bit akin to auction, but can be used potentially not just for inventions, but also to encourage other kinds of experimentation. So I've written a little bit on what I call market experimentation. Usually we think of intellectual property as encouraging technological experimentation, new inventions. But you can make the case that the problem that intellectual property addresses exists as well with market experimentation. That there's a danger that people will sort of just as people, we're worried if we don't have a patent system, people are going to free ride off the information that we get from your inventions, right? You're going to show that if you put some things together in a particular way, you get this valuable thing. So too, when you have market experiments, you have some new business model. People will free ride off information that that business model is a successful one. Right? People might be very skeptical at first. They think, oh, that's a stupid business model. Nobody's going to want that. Once they see that it's very successful, they may free ride off of it. And our IP system doesn't do a very good job of preventing that kind of free riding. And so we have less market experimentation than we would have in a system that gave you some kind of protection for it. So this mechanism is a way of trying to provide that protection, but in a way that really reduces the risk that we'll end up granting intellectual property rights for market experimentation unnecessarily. So let me kind of summarize the mechanism here, but let me kind of explain how this works. Let's suppose that you think there is a market in Long Island, and I think I came up with the example here. Yes, for a German-Peruvian fusion restaurant. Okay, you think this is the thing. You figured out that those foods work really well together. And I looked it up. There isn't one in Long Island. Okay, at least Google doesn't know that. There is one in Berlin. Okay, but not in Long Island. No German-Peruvian restaurant. Let's say you think the following. You think, look, if I open this restaurant and it's successful, right? It's going to be, if it's successful, it might fail. But if it's successful, it's going to be successful in a big way. People are going to realize this is just a great combination. German, Peruvian. And then people are going to open a lot of other German, Peruvian restaurants, and they're going to compete with me. Because in our existing patent system, you can't get a patent on, it already exists in Berlin, you can't get a patent
on opening a German-Peruvian restaurant in Long Island. So here's how it might work in the context of the system. You'd say, okay, I want to open this restaurant, and I'm willing to and I think no one is going to open it without these rights. Why? Because we may be at a point in time when we don't think that anybody will do this unless they're promised that if it's successful, they'll get the whole market for at least a period of time. So what you can do is you put down some amount of money, let's say $10,000, on the proposition that no one will open such a restaurant if you don't get the right. Okay, it's kind of some double negatives. But you say, I am betting that no one will do this unless you get an exclusive right. We need this exclusive right to get somebody to open this kind of a restaurant. Well, that would be published. Anybody else could then come forward and say, I actually think somebody is going to do it. Maybe that person's going to do it. Maybe they think you're going to open the restaurant anyway. And so essentially they would bet you, maybe $10,000, maybe even some lower amount of money. They would say, no. I think it's going to happen, even if you don't get the right. If anyone takes you on in that way, you don't get the exclusive right. You only get the exclusive right when nobody is willing to bet that this will happen even if you don't get the right. So if everybody thinks that, yeah, it's certainly not going to happen unless you get the exclusive right, then you get this property right. So this is a very different kind of approach. You can use it with market experimentation. You can potentially do it with technological experimentation too. A very different kind of approach to defining property rights. We would be relying on third parties to kind of make bets, predictions on what would happen if those rights are not granted. And we would grant the rights only when we think that they're necessary to achieve their ends. Okay, and so I've talked a little longer than I anticipated or intended to, but I did want to leave a few minutes for questions, comments, skepticism. Obviously, I'm happy to talk to people afterwards as well. But why don't I open the floor? Might have Professor Monica call on people pretty soon.
I have
All right, thank you.
I was wondering about more on the politicization point.
Okay,
so
good.
If you could talk more about how you're going to prevent people from, we see perhaps some of this in the arts in some countries where you have to be connected. You have to know the right people, and then that's how you get the prizes and the funding and different stuff, right? And that's not necessarily connected to how successful or useful the invention is going to be. And some of the mechanisms you showed help against some forms of politicization, but what will really help against that? Yeah, and so I think that there's some areas in which it's a greater concern than others. So I think if we have prizes where the government sort of announcing in advance, and then there's a lot of discretion as to whether you've actually done the thing necessary, you're going to have a relatively large amount of politicization. And also politicization is kind of two questions. One, do you get the money? And two, what areas should we actually fund? Right? And I think a lot of the prizes, it's kind of rife with things that have sort of political appeal for various reasons. Not necessarily, right? There's no one in the government making cost-benefit calculations, trying to figure out, well, okay, if we do this, what's the probability that somebody invents? What would be the benefit? No one's doing that. And even if they were, you can always fudge that and just get cost-benefit to come out however you like. So I think it's a pretty big concern there. And it's certainly a concern in the rewards context. But I do think that in the rewards context, there are ways of reducing them. I mean, if you imagine that you had, let's say, some of these reward hearings where involve Article 3 judges, right? They're doing lots of other stuff. They're not easy to manipulate politically. Maybe you don't have Article 3 judges, but have some kind of agency where people have to be, recuse themselves if they have any kind of financial interest and make some kind of assessments. Maybe you kind of compare inventions in pairs, things like that. I think there are things you can do to make it a less political process. Can you eliminate discretion altogether? No. And might it still be the case? There are sort of systematic biases. There are things that just people, our patent system lets you get patents on deceptive things. So those of you who have taken patent law have probably read the case in which there's a deceptive juice machine. Anybody remember this case? But patents, we're going to allow patenting on that, right? And maybe that's good. Maybe that actually even
enhances consumer welfare. It makes it seem like the drink is fresh when it's not. And maybe most people don't know, they'll be better off. But if it was a political process, we wouldn't have it. So I don't know. One can argue about it. Will people make the same kinds of decisions that consumers make? Similarly, maybe there are certain kinds of diseases that are more politically popular than other diseases. Right? And if you invent a cure for those diseases, you'll get more money. But the non-politically popular diseases, they afflict people too. So I certainly think there are reasons to worry. And, milk still has a very powerful point. But there are so many other problems with the patent system that at least is uncertain whether we can do better than that or worse than that. And I think it'd be worth experimenting in modest ways. Great question. Yes, sir?
Hey, so is IP on a national or international level mostly?
Okay, that's a great system. So, a great question. So, IP is implemented generally at the national level, but there are international treaties, the TRIPS Accord, for example, that require countries to offer at least a certain amount of patent protection, for example. And so that's kind of another big kind of challenge with a prize or reward system. So if we had prizes or rewards, instead of patents, would we just be benefiting the other world, the rest of the world, at the expense of ourselves, right? If we just say, oh, okay, you agreed not to get a patent, we're going to pay you money because we think you've done something great. Well, that's really nice of us as the United States, maybe, to help the rest of the world. But there are ways you can design a prize or reward system to say, well, you can still get your patents in other countries, but if you agree to forego your patent in the United States, we'll give you a prize or reward for your contribution in the United States. So one could do that. I mean, one argument in defense of the patent system is that it's rather remarkable that we've actually managed to achieve some level of international coordination. I mean, we can't coordinate on anything international, and yet pretty much every country has a patent system. Now, some people think that's bad. It's bad for developing countries, one might argue, but at least it's remarkable. And so, a legitimate argument against all these alternatives is, if we adopted one, how on earth would we get the rest of the world to agree? Moreover, if we just eliminated our patent system and if we followed the Bernie Sanders approach, we'd be pretty clearly reneging on our treaty obligations, which would lead to sanctions at the World Trade Organization. So there's a variety of problems associated with international harmonization, and that's kind of an important issue in this area.
Do you think there's been a lot of recent changes going on with IP law? One of them was first to file, where we moved more towards the international system. But then with all the changes in the U.S. to laws which they say favor, don't favor the patent holders anymore. So the Alice case and all that, where they say they're eroding at the rights of the patent system. Do you think that the prizes, rewards, auctions, and these other systems really become a weaker argument with all the changes that are being made in our system?
I actually think to some extent it could be better. So I think Alice is a great example. And Alice is a case that makes it harder to patent software. And there's a huge debate about patentability of software. For most of our patent attorneys think it makes a lot of sense. Computer programmers don't like software patents very much. But certainly one could say, look, if you don't like software patents very much, we want some incentive for people to come up with really innovative algorithms, right? Maybe a lot of software patents are kind of junky, but there are some software developments that are really valuable. If we could encourage them, and maybe encourage them earlier, they'd be great. So deep learning, for example, algorithms with neural networks in the last few years. It's an area that's completely taking off. And you might say, maybe if we had a better patent system, or some kind of better alternative to a patent system, maybe we would have had that earlier. It turns out there's a lot of challenges with making the patent system work well in the software context. And so maybe you can say, hey, maybe we should drop patents in the software context and have something else. Something like some kind of reward system in that context. You could imagine maybe as a compromise that perhaps, I don't think it's going to happen in the next 10 years, but perhaps you could imagine the legislature saying, we're going to keep the patent system, but we're going to take it out of the computer software context, we're going to have something else to encourage some kind of rewards for really big developments, not for, you get patents on, like, the most infamous one was Amazon one-click. So Amazon said, oh, you can just do one click. I'm sure many do this. You do one click, you get your thing. Well, they patented that. That was a very controversial patent because people think, well, that doesn't seem all that shocking, right? But, technically, I guess one could argue that it met the requirements of patentability. So you can say, no, we don't want junky patents like that, but for some really big things, maybe we'll have some kind of mechanism
do that? That's a great question. Any other, that says 2 minutes and 7, I don't know if you said that clock is slow, so I don't know if we're out of time or if we have.
Almost 7. Anyone have any last pressing question? If not, we can just thank our speakers. So thank you. We will be having a reception with food and drinks and everything in the atrium. So everyone's invited to.
Thank you all very much for coming.
Thank you.
Good luck with the finals.